So what's the criminal court process in a misdemeanor DUI case? The criminal court process in a California DUI case will depend on whether the offense is charged as a felony or as a misdemeanor. DUI offenses are typically charged as felonies if you're involved in an accident that results in injury or death, or if you're arrested for your fourth drunk driving offense within 10 years, as calculated from arrest date to arrest date. Misdemeanors and felonies are distinguished by potential punishment. Misdemeanors carry up to a year in county jail by definition. Felonies are punishable by a year or more in state prison and can even result in a life term in prison. In California, your attorney can appear in court on your behalf in a misdemeanor DUI case while you go to work or otherwise go about your normal business. This luxury is not available in felony cases. The first court appearance in a misdemeanor DUI case is called the arraignment. This is when you, or your attorney, will be formally advised of the charges against you and given police reports that justify the charges. While it's possible to plead guilty at your arraignment and settle your case immediately, it's generally not a good idea to do so. If you plead guilty at your arraignment, you'll be accepting responsibility for the DUI offense as charged. As your attorney investigates the case and makes motions on your behalf, it can improve your prospects at trial or result in a favorable plea bargain or settlement down the line. After your arraignment, there are typically a series of pretrial conferences and hearings. These hearings present an opportunity to conduct additional investigation by way of informal discovery requests or even formal discovery motions. And motions are simply a formal request to the court that they order certain actions. In these requests and motions, your defense lawyer should ask the prosecutor to turn over additional items of evidence that are not in the initial arrest reports. Other motions that can be heard at this point include motions to suppress evidence, alleging, for example, that your traffic stop was illegal and therefore the evidence collected must be suppressed as the fruit of a poisonous tree. Or a pitchus motion, which is a request to the court to order the release of information from the arresting officer's private personnel records. After the various pretrial motions are submitted and weighed by the judge, there will be one of three outcomes. The charges against you may be dismissed, your case can be settled, or else it will be set for trial. A trial in a DUI case is just like any other criminal case. It includes jury selection, opening statements, examination and cross-examination of all the witnesses, closing arguments, and jury deliberations. In order for you to be convicted, the prosecutor must convince all 12 jurors, or the judge if you opt for a court trial, that you are guilty beyond a reasonable doubt, to the exclusion of every reasonable doubt. If not, you'll either be acquitted or a mistrial can be declared if there's no unanimous verdict. If you or someone you care about needs a lawyer, call us right now for a free consultation. Our toll-free number is 1-800-NO-CUFFS, as in, get those handcuffs off of me. 1-800-NO-CUFFS is 1-800-662-8337. Call us now or check us out online at nocuffs.com.